Tonight, Kirby Farris with the law firm of Farris, Riley & Pitt. He's here to explain a sneaky contract clause known as mandatory binding arbitration and how it could have a devastating effect on your injury claim. So for folks tuning in tonight and watching, what do they need to know about this?
You know, Tiffany, arbitration's been around a long time, but for many years it just applied to business contracts. But some time back, there was some appellate briefs written and appellate work done, and the Supreme Court has determined that those arbitration clauses apply now to consumer contracts. So let's talk about first what an arbitration clause is. It is a portion of a written agreement that you enter into with a business that says that you are relinquishing your rights to bring any legal action against a business to court or to a trial. You lose your right to a judge and a jury making a determination about some dispute that you have with a business. Now, that can be fraud, it can be them not doing what they tell you they're going to do, it can be a defective product that gets put into arbitration. So here's the things that we want you to remember. In arbitration, the arbitrator makes the decision about all of the outcomes concerning your dispute, and there's no right to appeal. So the first two things on your screen there are intertwined. If the arbitrator isn't quite right about the law, then you don't get to appeal that and have an appellate court review what the arbitrator has done. And usually, as you see in the third bullet point, usually this is a portion of the contract that is deep within the contract. Here's my advice to you. Read the contracts that you sign, and if you find an arbitration clause, ask the business owner what the arbitration clause is, what it means, and try to negotiate it. Maybe it's a clause that you can get out of the contract that would ultimately benefit you as a consumer.
All right, it's great.